What estate planners need to know about Social Security, Medicare, and the self-employment tax. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Ed Beckwith, ACTEC Fellow from Washington, D.C. The eligibility rules for Social Security and Medicare, the federal and state income taxation of Social Security, and the ability of dependents to receive those benefits are rules estate planners need to know. Self-employment tax rules also can be very important. To give us more information on these topics, you will be hearing today from ACTEC Fellow Greg Guderian of Tucson, Arizona. Welcome, Greg.
Thank you, Ed. That was a great summary of what I'm about to talk about. I think you covered everything. But seriously, is that one of the things that estate planners need to be able to advise their clients on is when to apply for Social Security and how it covers dependents, including grandchildren, children, multiple spouses, if you have ex-spouses, as well as parents in some situations, and how that all fits in with Medicare. The self-employment tax is one aspect of it, and I'll deal with that first and then go to the benefits that are available. A lot of the focus of tax planners is to reduce or eliminate self-employment taxes to the maximum extent. And those self-employment taxes only apply to people that are in sole proprietorships, people that are in partnerships. That's the starting point. So employees have withholding taxes, which are their Social Security taxes and their Medicare taxes. And by the way, those taxes end up running, as we all know, 12.9% and 2.3% for the two combined taxes. The tax that is for Social Security phases out now at $132,900. So any income earned above that level is not subject to Social Security taxes, but is fully subject to the Medicare tax of 2.9% and is fully subject to an additional Medicare tax of 0.9%, but that only applies to people who have much higher income, above $200,000. So a lot of our clients are self-employed and want to reduce their self-employment tax, especially the Medicare tax. There's two ways of doing it. One way is an absolute guaranteed that it works is creation of a limited partnership. I'll give you this example. I have a client who owns multiple pawn shops, and those pawn shops were organized as separate limited liability companies. The client was over age 70 and wanted to reduce his tax liability. We put all of the pawn shops into a limited partnership, and this only works for limited partnerships, does not work for limited liability companies, does not work for general partnerships. There's a statute, Section 1402A as in Arthur 13, which specifically says that those shares of income allocable to a limited partner are not subject to self-employment tax. This is an interesting provision that was put in the law when both you and I were young lawyers. It was to avoid allowing people to qualify for Social Security by becoming a partner in a partnership. Typically, this was for the homemaker spouse who had no Social Security benefits for that homemaker spouse, and this was a way of getting them benefits. So Congress responded by enacting the statute 1402A13, which says, no, you're not going to qualify for Social Security as a limited partner. So that's still in the statute, and it's not used nearly as much as it should be used by putting businesses in this type of entity. The other one is Subchapter S corporations, which probably has more use. In Subchapter S corporation, the K-1 income, which is the earnings that a shareholder pays tax on whether or not there's ever a distribution, that is not subject to self-employment tax. And we see a lot of litigation, a lot of cases with the IRS, where the IRS is saying, you paid yourself too small of a salary. They said, Ed Beckwith, you're worth more than $12,000 a year as an attorney. You're worth at least $24,000. So we're going to increase your compensation income by the additional amount. And the $200,000 that you took out as dividends, we're going to treat a good portion of that as compensation. So a lot of people tried to avoid this tax in probably not necessarily a wise way. And I say that intentionally because of the fact that we have to think, what benefits does Social Security apply or give us? What benefits do we get for what we're paying in? And if we think about it, is that if I'm a younger person and I die when my children are under age 19, they get benefits as dependents until they turn age 18. So I'm paying for a form of insurance. The other thing is that it also gives my spouse benefits. So another form of insurance. So I don't want to cheat myself or cheat my family by not paying money into the system, either as an employee or as someone who's self-employed. So that's one thing that we need to advise our clients about, is think about what you're getting for the Social Security taxes that you're paying in. Now let's look at the Social Security benefits, and I described briefly that it's not only benefits to myself and yourself, Ed, as a retiree, but it's also the benefits that our spouses, children, parents, and grandchildren can potentially receive. The maximum amount of benefits that we can receive is about $3,770 if we're age 70. If we are age 65, it's $2,757 a month. And the whole question initially that most of the literature is on is, when do we start applying for benefits? At age 66 when we first have the opportunity, or 67 if you're born after 1954, or do we wait to age 70? And I think there's three factors it depends on. One, your health. So ask your doctor, are you going to die soon? Because you want those benefits as soon as you can get them, which would be age 62. And there's a reduction if you get it at age 62. Second question is, do you need the money? Okay, well, I'm not sure that Ed may need the money, but I don't really need the money because I'm still working, so I don't need the money at this point. And then the third thing is my marital status and other similar type issues. My marital status, if I defer till age 70, my wife gets whatever I was getting at my death. So if I'm at $3,770 because I have died, my wife will get surviving spouse benefits of $3,770. So she benefits by that. So those are the type things, I think, though, for most of the population, and not simply people that are higher income, they'll take Social Security as soon as possible, which may make sense because they need the money. It's my understanding that it's the primary retirement income for about 90% of the population, which is an astounding number when I first saw it. The coverage, okay, is that it applies for surviving spouses, and a surviving spouse will get the higher of what he or she was originally receiving, or mine, okay? The other thing that comes in is that how long do you have to be married in order to be a surviving spouse? And I was shocked when I found out the answer. It's 9 months. 9 months of marriage. And the very first case I ever got involved in that involved that was a woman who was getting married who was going to lose her Social Security benefits because she only had Social Security benefits through divorce. Well, she was going to lose those when she remarried. So we drafted a prenuptial agreement that said if her husband, who was my client, did not live 9 months, she was going to get alimony to make up the difference. There's other benefits as well, as that my wife can get benefits not as a surviving spouse, but just as a spouse. She can get 50% of what my benefits are. So that's for the spouse that was usually the homemaker, or somebody who was not in the employment system themselves. Upon divorce, if you've been married for 10 years, you're going to get Social Security benefits through your ex-spouse. But as I mentioned earlier, you could lose those. Where it also comes in, Social Security benefits, is for dependent children. And we have two classes of dependent children. I mentioned one class, the child that's under age 19. So if I die and I have children under age 19, they would get Social Security benefits. They also get Social Security benefits if I start receiving Social Security benefits because I'm disabled or because of the fact that I have retired. So those of us that have children later in life, and we're now collecting Social Security because we're at 66 years old, our children get a check. Strangely enough is that I've had many clients who have had to adopt their grandchildren. They adopted the grandchildren because there were substance abuse problems with the parents, and those grandchildren became children and they were getting Social Security benefits. So we see those types of benefits applying. We also see it going for dependent parents. So my mother, who was living with me and I was providing half of her support, if I had predeceased her, she would have gotten Social Security benefits through me. So when people think about avoiding paying Social Security tax, look at the range of benefits that are available before you take those steps. Think it through. And the ACTEC attorneys, as advisors, need to be able to advise our clients. These are the benefits. Think about it. Maybe you want to pay the maximum into Social Security. Thank you.
Greg, thank you for educating us on these complicated yet very important tax rules.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review. Follow us on Facebook and Twitter at ACTEC Talk.